Hey everybody, welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel, doing our live stream like we like to do each and every Thursday night, where we talk about all things debt related, debt collection, lawsuits, bankruptcy, wage garnishments, and all those other horrible things. That's what we are going to talk about tonight. If you've been to my channel before, we try to do these live streams each and every week to really go over topics that you want to talk about. And so if you have questions, if you're dealing with the debt issue, if you're dealing with a lawsuit, if you're dealing with, like tonight, we're going to talk a little bit about LVNV Funding, who have been flooding the country with lawsuits. We're going to talk a lot about that as far as ways to deal with it. But I also, we talk about bankruptcy. I am an attorney in the state of Arizona. This is what I do all day long. I've been practicing for about 23 years. And so I like to kind of share this information because I know that when you have these serious debt problems, you go to these dark places. You know, we think we're going to jail. We think that there's no way out. When in reality, we can put together a plan, help you deal with it, help you get this thing in the rearview mirror and move on. I'd like to thank our sponsor for tonight. Each and every week we have Solo. Solo is a great company that can help with resolving debt, filing answers to lawsuits. They have a really cool platform that helps with debt settlement, where they have connections with companies like LVNV Funding, where they can connect you two together and help to make a settlement where you don't even have to talk to them. You don't have to have those uncomfortable or awkward situations. So it's a great way to support yourself, support the channel, but the link is there in the chat. If you do have a question, go ahead and put it in the comment section, the chat section on YouTube. If you're watching this on X or Facebook, go ahead and leave a comment. I'll put it up on the screen and we can talk about it. My weekly disclaimer, while I am a licensed attorney, I am not your attorney and I can't give you specific legal advice. I'm not licensed anywhere else. This is a guy talking on YouTube. Take it for what it's worth. If you want to set up a consultation and you're in the state of Arizona, I have put my link in there. Click on that and you can actually pick a date, get on the calendar. You'll talk to me. There's no one else to talk to, just me and my staff. I'm the only attorney here. And I can kind of walk you through and see what we can do to help you out. All right, let's jump into some of the comments. First of all, so I entitled this one LVNV Funding. The way in my law practice, again, here in Arizona, we're seeing a lot of lawsuits filed by LVNV Funding. We always see a lot, but we're kind of seeing a wave of them coming right now. And that's because part of it's understanding how the debt collectors work, the debt collection law firms. The big one here is Gerstel Law Firm. They're also in, I believe, Minnesota. They file huge volume. And so a lot of these, you'll see it's just a few attorneys, and all of a sudden they'll hit the courts with 1,000 lawsuits, with 500 lawsuits. They do these big filings all at the same time. And so I start getting my phone ringing out the hook saying, hey, I just got served with the lawsuit. What do I do? And so I wanted to talk about LVNV Funding, specifically who they are, and what are some approaches as far as dealing with them. Now, LVNV Funding is a junk debt buyer. This means that what they do as a company, they go to original creditors like Citibank, Synchrony Bank, different credit card companies. Those companies have charged off these debts, and what they do is they put them together in a big spreadsheet and they sell them on the open market. And they sell them at a discount because they're saying, hey, these accounts are charged off. We haven't been able to collect on them. So we'll sell them to you for 3 cents on the dollar or 4 cents or 5 cents on the dollar. LVNV Funding is one of these big debt buyers. They file, I think in all 50 states now, they file lawsuits. You may have also gotten calls from a company called Resurgent Capital Services. It's kind of a sister company that deals with LVNV. But they file these lawsuits in huge volume. Their whole goal is to get a judgment against you, and that way they can garnish your wages, they can levy your bank accounts, and they can record a lien against any real estate that you own. That's typically the three ways that we see that these creditors, like junk debt buyers, that they collect. And 95% of their lawsuits plus end in a default judgment. People don't respond, they don't file an answer. And if you don't answer the lawsuit after you get served with it, the court will enter a default judgment against you. And then you're in a situation where not only did they give them the full balance, but a lot of times there's interest, attorney's fees, court costs, and just balloons and gets out of control. Not only that, most judgments accrue interest the longer they're out there. So I tell people, a lot of people say, you know what, they can't collect on it. They didn't pay, they have a $10,000 lawsuit, but they only paid $300 for it. Doesn't matter. If they get a judgment for the full balance, if they can prove that they own your account, then it's a situation where the court's going to allow them to do that. And those judgments can hang around forever. In Arizona, judgments are good for 10 years, and then they can be renewed every 10 years for the rest of your life. So it's important, if you get sued by a company like LVNV Funding, that you file an answer. When the process server, the sheriff, constable, whoever it is who drops it off, make sure that you look at the summons, see how many days you have to respond, and then file an answer with the court. And if you're working with Solo, Solo, they actually have a program that'll help you to do that. And that will be one way you can do it. That you can do that. If you're in Arizona, you can contact me. We can help you file an answer and actually help you deal with the whole thing all over. If you have questions on LVNV, some specific strategies that I use all the time in my law practice, as far as how to either settle the debt for less than what's owed, or how to actually contest it, because there are defenses to it. I always say LVNV Funding, they're in this situation. They didn't loan you money. You didn't agree to pay them money. So they've got some hurdles to get over if they're going to be able to get judgment granted in their favor, because they have to prove all of that. So if you have questions on those, LVNV or any of the others, let me know, and we can jump into that. So, okay, there were some questions from the channel that I wanted to jump into that are kind of right along these lines. This one was from @19AKG, said, "Hey John, what do you think about advice that says fight it out in court, targeting ownership of the debt? Is this a good strategy, or would you say arbitration is more likely to succeed?" So this is a good question. This kind of goes to the heart of what I was just talking about earlier. With a debt buyer, and I treat debt buyer lawsuits totally different than original creditors. If you get sued by, say, Capital One, American Express, Bank of America, a lot of these companies that don't sell their debt, or at least don't sell it in most of their debt in huge volume, like some of these other banks. If you're dealing with that, then the debt buyers, you do have some strategies. One is to fight it out in court and try to make them prove ownership. And one thing that's important to remember, if you've been sued by a company like LVNV, Portfolio Recovery, Midland Funding, they bear the burden of proof. They have to show that you had the underlying account. They have to prove what the terms of that agreement were. They have to prove the balance, that you breached the contract. And then the pinky one, they have to show that they're the owner of your account, not just a big portfolio of accounts, but yours. And the reason why I say is because often when you look at the paperwork, you'll see the bill of sale or the bill of assignment. They provide just this really general paperwork saying, hey, Bank of America is sold to LVNV, this portfolio of accounts on this date. And then it'll say something like, see the attached accounts. And you look and there's nothing there, or there's just a fully redacted spreadsheet. That's not enough. They can't just show that they generally bought some accounts. They have to show that they bought your account. So you can fight that out. Some people elect to get it out of the court system altogether. If the terms and conditions of your credit card have an arbitration clause in it, and you're going to have to get a copy of the terms and agreement for your credit card, a good place to do that is at the Consumer Financial Protection Bureau, the CFPB. If you go to their website, it's a government website. They actually have a database of all the terms and conditions of every credit card. So you can go find your credit card, download it. If there's an arbitration clause, you can take it out of the court system. You have to ask this. You have to go to the court, file a motion, say, hey, I want this out of the court system, and I want to be able to pursue this through private arbitration. So there's like these private arbitration companies. The big one is AAA, the American Arbitration Association. You can then file the case in there and have it dealt with in there. It's more user-friendly than a court system. It's a lot more relaxed. There's not as many, there's not a judge. There's just a private arbitrator, and there's no rules of evidence. It's just a lot easier for them. Also, a lot of times the debt buyer won't even follow you in there. The filing fees are insane for companies like that. They're different. In a court, the filing fees are basically the same for the plaintiff and the defendant. Like at AAA, like your filing fee will be $200. The creditors will be like $3,000. And so a lot of creditors, particularly if it's a small amount, they'll be like, you know what, we're done with it. So some people will go there just because it's easier to work. And then a lot of times the creditor doesn't even follow them in. So that's something to think about. It really depends on fighting it out on ownership. You really need to see, is there evidence of the transfer? And I can tell you the ones that I love to fight in court the most, if it's been transferred multiple times. You'll see this, that, like a company like LVNV might sell it to a third party, then to a fourth party. And those are the ones where they really struggle to actually prove ownership. So, okay, let's look at some of the questions that are coming in here. Edwin says, does bankruptcy remove judgments? Good question. So let's say you file Chapter 7 bankruptcy and you got served, or you didn't respond to the LVNV judgment. Any debt buyer, whoever it is, they have a judgment against you. So yes, a Chapter 7 bankruptcy will wipe out that debt. They cannot collect on the judgment. The only kind of issue becomes if they've recorded the judgment with like the county recorder and you own real estate, there could be a lien on your home. If there's a lien on your home, you have to file a motion in the bankruptcy to avoid that judgment lien. If you don't do that, then that debt and the judgment will survive the bankruptcy. So it's important, particularly if and this is why I say it's helpful to use an attorney, because they need to be able to search and see, is there a judgment lien there? If so, we need to take care of it during the bankruptcy. I can tell you this, if you filed bankruptcy even in the past, and all of a sudden you come back and you find out, hey, there was a judgment there that I didn't even know about, you can actually reopen your bankruptcy and get rid of that lien. So yes, you can get rid of it. If they haven't filed a lien, it gets rid of the debt, gets rid of the judgment, and it is done completely. All right, Alex down in Yuma says, if a creditor debt buyer gets a judgment against you, can they foreclose on your house? How likely it is that they would pursue this option? Support from Yuma, Arizona. Alex, good question. So if they do get it, if the creditor gets a judgment against you, like I said, they can record it. It can act as a lien against your home. Are they going to foreclose? I can tell you my experience here in Arizona where I practice. I have never seen that happen with a credit card type debt. The main reason is because Arizona has a pretty good homestead exemption. So if you're in your house, if you live in your home and you're buying it, as long as you have, at least right now, I'm recording this in 2025, this will change next year a little bit, but you can have up to $425,000 of equity in your home. And as long as you don't have more than that, they can't foreclose on it. They can't foreclose on your house just to get nothing. And so the homestead exemption protects you there. I can tell you, even if you had more than $425,000, it's rare. Part of it is because, if they foreclose, if you have a mortgage, they have to pay off the mortgage first. If there's a home equity line of credit, if you have solar, if you have all those things, they're usually like third or fourth in line. So I don't see that happen very often. It's possible. That's the whole point of the lien. Usually what they do is these debt buyers and collectors, they've kind of played the long game. They'll put the judgment out there knowing that, hey, eventually you're going to sell, you're going to refinance, you're going to die, and they're going to liquidate your house. Then they will get paid. And you'll see that often. If you're trying to sell your house, trying to refinance, the title company will come to you and say, hey, we found this judgment. It's got to be dealt with. We've got to pay them out of the proceeds, or you got to get it settled, something like that to get it squared away. So, all right. Mike says, I'm planning to purchase your Consumer Warrior University course. How much do you think this course could help me with filing an answer to Capital One's motion for summary judgment? In the course itself, it is something where, we deal with motion for summary judgment. What a motion for summary judgment is so they file the lawsuit, you respond to it, maybe the court sets a trial date. The creditor, in almost every debt collection case, they're going to come in with a motion for summary judgment and say, Judge, we don't need trial. Just look at all our documents and tell us if we win the case. You then have to respond to it. And it's different than responding to like the complaint. Like your answer, you're just admitting, denying the allegations, that kind of thing. If you're going to come in with a motion for summary judgment, you have to attack their case and point out why there are things in dispute. Basically, summary judgment should not be granted if there's a factual dispute between the parties, which with the debt buyer there is. They're claiming, hey, I'm LVNV Funding, I bought this account, and we're saying, we don't agree with that. You didn't loan us this money, and your evidence doesn't support your ownership. The court should deny it, but it will help you with that. The Consumer Warrior University as well gives you access to all of the tutorials that I've created and templates and all that. And there's one specifically on drafting a motion for summary judgment response. I can tell you, I fully admit, that's the one area where self-represented people struggle the most, particularly if they don't have some type of help doing it, but it'll definitely walk you through the process and show you how you can put that together. So, all right, Derek says, arbitration got my case dismissed. Midland asked to dismiss without prejudice. I responded that it be dismissed with prejudice, still waiting in the court to respond. Thanks, Sean. Awesome. Derek, glad to hear that that was helpful. So, all right, let's see here. Edwin had another follow-up, says, I plan to go file for Chapter 7 bankruptcy. Is it true that someone comes to your house to see what they can take and sell? And would my wife have to file bankruptcy, or can I do it myself? Those are all great questions. I get those questions frequently. To the first one, is somebody going to come to your house? No. I guess, could they come to your house? It's possible. I've never seen it happen. The bankruptcy court, what is really the foundation of it is the paperwork is extensive. Like it's like a 110-page document you have to submit. And so like what we do is we gather all this information on creditors and assets and transactions and income and monthly expenses and all that kind of stuff. And then we submit it to the court. The bankruptcy code requires that you disclose all of your assets, all of your debts, certain financial transactions. And what they do is they don't come to your house to confirm. They just put a big old hammer out there if you intentionally fail to disclose something. So there's harsh penalties if you're intentionally not disclosing something. So, if I file bankruptcy and I have, this house in wherever, California, and I'm like, I'm not going to tell anybody about this. And then I file bankruptcy and they find out about it. Not only can they still go after that house, they can actually pursue me. They can do perjury charges. There's bankruptcy crimes. And they do pursue those things. I mean, not a lot. It's not like it happens all the time. We always seem to see it with these reality TV shows, where they make a bunch of money and then they file bankruptcy and then they don't disclose something. And those are the people the Department of Justice usually tends to make an example of, to say, look, you got to disclose. Our thing is, when in doubt, disclose so that it doesn't become an issue and you don't have to go down that road. So good question. Oh, and as far as the second one, does your wife have to file with you? The answer is no. Married couples do not have to file together. I frequently get this question because one spouse is like, either the debt's not mine, we haven't been married that long, or is something where they're trying to save one person's credit. I can tell you in states like Arizona that are community property states, there is some risk in doing that. It's not a great risk, but there is some risk because in community property states, basically community property law says, look, if you get married here in Arizona, any debts that you have or assets that you get while you're married are considered joint, almost without exception, regardless of whose name they're in. So if I file bankruptcy and my wife does not, they can't come after my wife during the bankruptcy. And once I get my discharge of that debt, they can't come after my wife even while we're married. Let's say we get divorced, then they can come after the ex-spouse. So, the practicality is I don't ever see that happen. I think there's only 9 community property states. And in most jurisdictions, I think the creditors just, once you file bankruptcy, they put it in the bankruptcy pile and that's the end of it. But there is some risk. I think it's minimal. Definitely something to talk to an attorney about to see, if that's going to be in your situation. So, all right. From the channel, it says, when there are settlements, do these amounts have to be paid flat out or are payments offered? This is Luxury Naturals. Oh, good question. So if you're being sued, even if you're not being sued, if you're just trying to negotiate it, the beauty about settlement is you control the terms. You can propose to the creditor whatever you want. Once you get into court or arbitration, sometimes it's different. Then you got a court, you got rules you have to follow. But it's something where if you're trying to settle a debt, you can go to them with a payment plan. You can go to them, say, hey, I'll pay $100 a month, no interest, 12 months. That's my offer, and see what they say. I always say you don't ever want to propose something you can't do. You got to propose something that's realistic for your situation. I can tell you, you often will get better deals if you can come in with a lump sum and if you can come in fairly quickly. Sometimes timing makes a big difference too. If you're at the end of the quarter, the end of the year, sometimes they'll take a better deal overall. So that is, those are the kind of things to think about. But just come, sometimes we'll get creative and we'll say, hey, client can pay $1,000 now, and then we're going to do payments of $50 a month for 6 months, and then a balloon of $2,000 at the end. Whatever it is, you can be creative with that, and make sure you get it in writing. Before you pay a penny of it, make sure you get it in writing so that there's no confusion going forward about what's owed, what's not, if it's resolving the entire debt, or is this just a payment towards it. You want to make sure that's all very clear. All right. At Linda Gatstead 9810 said, can they serve you by phone? I don't know all the laws in all 50 states. I'm going to say no on this one. So when a company, whether it's LVNV Funding or Capital One or whoever it is, they file a lawsuit, normal procedure is they file the complaint with the court issues a summons, and then they hire somebody like a process server, sheriff's deputy, constable to then take that document and serve you with it. Most jurisdictions require they show up at your house and put it in your hand, and that's what starts the clock ticking. They will then file something called a certificate of service or an affidavit of service with the court so that you have the opportunity to respond to it before they enter any kind of default. So, but phone service, usually, they've got to provide you some kind of written document. It can't be just some debt collector calling you up saying, hey, you've been served, good luck kind of thing. You can't do that. So, I would recommend, if they have, what I would do is if someone calls you and says that there's a lawsuit that's been filed, I would contact your local court, see if it's legitimate, because sometimes shady debt collectors will, they'll say, hey, we've sued you, or we're going to sue you. And then when you look, they haven't actually done anything. So I would recommend contacting the court first to see if there is any legitimacy to it. But no, usually service by phone is not sufficient. It is possible for them to get something called an alternative service order if they've tried to serve you multiple times and you're not home. But that usually allows them to post it on your door, mail you a copy, certified mail, all those kind of things. So, all right. Those were all great questions for today. I think we'll wrap it up there. But hey, if you have any further questions, put them in the comments. I like to do this each and every week. We can talk about it. Again, if you're in Arizona, click on the link, set up an appointment with me. I'm happy to actually talk to you on the phone, do a Zoom call, whatever it is. And if you're looking for some help just drafting an answer, check out Solo, settling a lawsuit, all that kind of stuff. They're there to help you. Appreciate everybody checking in tonight. And with that, we'll see you next.